Hey, it's James, Father's Rights and Resources, hashtag how I got custody. I want to tell you the number one thing that I think attorneys violate all the time in their ethical code is RPC 1.4. That's Rule of Professional Conduct 1.4. Now, where I get this from is if you go to the American Bar Association or you just Google ABA Rules of Professional Conduct, you can look those up, and they're the model rules that a lot of states adopt or follow. And I'm looking at it right now. And some states like Washington here, I just saw California's a bit ago. Even the numbers correspond the same, but some of the content changes a little bit because each state's bar association might add or change one thing or another. So Rule 1.4 talks about communication. Rule 1.1, I'm looking at the American Bar Association. Your state may have something different. You can throw this at your attorney when you're dealing with them, or you can find rules of professional conduct, Texas or Mississippi or whatever state that you're in, and look at that specifically because your attorney is bound by that. Now, the rules of professional conduct are just some rules on a piece of paper that most lawyers ignore all the time. But the number one rule that I see attorneys violate all the time is this one, and I'll tell you why and how you should check your attorney on it. And this is how you hold your attorney accountable. I will note that Rule 1.1 is competence and 1.3 is diligence. A lot of times attorneys are lazy or shiftless and don't do what they're supposed to do, so they might be violating the diligence rule. Half of them are totally incompetent idiots in family law. The other half are just lazy bums. And there might be 3 or 4 good ones out there in the country. Who knows? So if we look at Rule 1.4, it basically says that an attorney is obligated to communicate with you and keep you informed about what's going on in your case. This should kind of go without saying and should be common sense. But attorneys violate it all the time. So I got a light flashing off and on here. Sorry about that. I'll just turn that one off. That's annoying and distracting. Yeah, that's better. So 1.4 says there's a couple of subsections to it. Promptly inform a client of situations that are going on that they need the client's consent. And there's a lot of attorneys who will just sign off on an agreement or a mediation or go into a secret hearing in court and just sign off on stuff and not even consult with their client. So there's a violation right there. On the American Bar Association, subsection 1.4A2 says reasonably consult with the client about the means by which the client's objectives are to be accomplished. Here's the biggest one right here. Reasonably consult. And when you're analyzing or you're looking at the law yourself or rules or something like this, look at every word and what it means and think about what it means. Because attorneys like, oh yeah, we're supposed to do that. They just flippantly gloss over it. They don't do what it actually says to do. And you should hold them to the fire. It says reasonably consult with a client about the means by which the attorney's objectives are to be accomplished. Nope, doesn't say that. It says by which the client's objectives are to be accomplished. The client. Now, it doesn't say they have to do everything the client asks, because the client might ask for something crazy and the lawyer can't do it or realistically can't. But they have to at least consult with you, and not just consult. Read every word. Reasonably consult. Not just, you want to go for custody? I don't know if that's going to work. That's not reasonably consulting. Reasonably means somebody with, what a reasonable person would do. Okay, let's sit down and talk about this. You want to go for custody? Well, I've never gotten a dad custody. What attorneys usually say is, dads can't get custody or 50-50, so let's just go for every other weekend. You know why they can't? And I've talked about this in other videos. Because they never try and get it, so the culture of the courtroom is dads never get custody because the attorneys never try it. And the attorneys are the one who could change the culture of the courtroom. They could change what they ask for all the time and start influencing the judge why it's in the best interest of a child for a father to have custody in a situation. But they don't even attempt that because they come out of law school, do what their law firm boss tells them to do, and they just follow through with that and never try. I had a guy who... I gave him some case law that I found and looked up for him, and his Washington State Supreme Court case law, and he showed it to his attorney. And it's the Supreme Court of Washington, and it's what the court should follow. And the attorney's like, where did you get this from? Oh, this guy James. Oh, that father's rights nutcase. And then started bashing me. Well, whether I'm a nutcase or not, that was Washington State Supreme Court law. And he wanted him to go for custody And it was the Kovacs case, Kovacs, where a dad got custody because a mom was withholding the child, trying to move the children away, and undermining the father, and she had a mental health issue that caused her to do that. Bipolar disorder, narcissism, something like that. That got him custody. And then she appealed and got custody back, and the Supreme Court said, no, the Court of Appeals got it wrong. It was right the first time around, and they reversed back to custody him. So he shows that to his attorney, like, look, guys can go for custody. And he's like, that nut job, James, and started bashing me. Again, it doesn't matter who the messenger is. Is that the truth? Is that an actual case? So the attorney blew off his own client and didn't reasonably consult with how to accomplish that, because that was a goal of his. And then the client said, well, how many guys have you ever gotten custody? And the attorney said, in 20 years, 0. So he's never even gotten a guy custody, and that's why he blew that off, and that's why he's an incompetent moron like the rest of them. So an attorney's supposed to reasonably consult with you about how to accomplish your goals and at least hear you out. Most attorneys are like, oh, this is how we do it, this is how we operate. Okay, yeah, you want 50-50 your custody. Now that's not going to happen. And they just move on without even consulting with you. And later on in the rules of professional conduct, it said when you violate these rules, you commit malpractice. So here's what I would do and what other guys have done. I never communicate with an attorney, with anybody important, only over the phone. That's dumb. That's stupid, because there's no paper trail, and that doesn't exist. Text messages maybe, but they can just say, oh, you manipulated and faked the text message. What I do with an important letter or communication, I will email it, I will fax it, and I will send it certified mail and or deliver it in person and get the attorney's secretary's stamp that it got to his office. And there's no way he could say he didn't look at his email, his fax, his incoming mail and incoming stuff at the desk. There's no way he can miss it. And what I do, when I deal with letters, I demand stuff from people. Like, you write a letter and say, hey, I want to talk to you about doing a deposition on the mother, or I want to talk about going for full custody, I want to talk about changing my order, or asking for a mental health evaluation on the mother, or I want to talk about reconsidering the last order because we only got 10 days, I want to hurry up and do it. So get back to me within 24 hours and give them a deadline in writing. Maybe the first time you only do it for email because that's the way you usually communicate. But after that, if they don't get back to you in 24 hours, then you cite the rules that they took an oath to uphold. You know, Mr. So-and-so, and then write it in a formal letter, in email, and fax it, and deliver it to the office in person or certified mail. I'd rather just deliver it so it's there when I want it to be. And say, the rules of professional conduct say you're supposed to reasonably consult with me about this. You didn't get back to me within 24 hours. This is an urgent matter. Get back to me within 24 hours from this point. And then if they don't do that, then say, you're now violating the rules of professional conduct, which is a form of malpractice. I need you to get back to me or I'm going to file a bar complaint against you. And that will light a fire under an attorney's butt. Usually the first time you write a letter, it will. The second time you do it and you cite that you know the rules of professional conduct because they want you ignorant, that'll get their butt in gear. And when I've dealt with guys who got royally screwed by attorneys and they fire their attorneys, what I have them do is I say, first, write the attorney and get a statement as to what your balance is. Because if you fire them, they'll conjure up a whole bunch of stuff that they didn't do and bill it, and then so all your money's gone. Like say you have $2,000 left, or you owe them money. I've had guys and gals who owe their attorney money, and they write them a letter and cite all the different rules of professional conduct. I would go down all of these and find out what's wrong with your attorney. But this is the number one most important one to your case, and the number one why they suck so bad, because they never do this, because they're juggling 20 other clients and they think they can blow you off and get away with it, and they don't want to try that hard. So I write them, if somebody wants to fire an attorney, find out how much is in your balance and then say, I want my money back, or I want another $1,000 back, or I owe you $2,000. Let's just walk away. You're fired, and if you give me the $2,000 credit or you forgive the debt, then I'll forgive all this misconduct and cite all the rules of professional conduct. You didn't get back to me on time, RPC 1.4. You didn't show diligence here, RPC 1.3. You didn't do this, you didn't do that. You didn't even tell me another rule of professional conduct letting you know your rights and stuff. You didn't even tell me I could do a motion for revision or reconsideration within 10 days. You didn't even tell me we could do a deposition. You didn't even tell me about the discovery process. And then tell them how that's all malpractice, and if they don't give you money back, then you'll file a bar complaint and sue them for malpractice. That's what I would do. And then I would follow through with that stuff if they just laugh me off or blow me off. And then I'd be picketing and protesting their office saying what a con artist they are. So RPC 1.4, the biggest ethical violation of most attorneys.